Many civics teachers nationwide will tell students that Congress has the power to adopt any law it feels is, quote, necessary and proper, or, quote, in the general welfare, close quote. This is untrue, as the following quotes from the Virginia Convention will show.
The sweeping clause, as it is called, the necessary and proper clause, is much dreaded. This formidable clause does not in the least increase the powers of Congress. It is only inserted for greater cautions and to prevent the possibility of encroaching upon the powers of Congress. No sophistry will be permitted to be used to explain away any of those powers, nor can they, i.e. Congress, possibly assume any other power but what is contained in the Constitution, without absolute usurpation.
So what are the implications here? If the federal government, citing the necessary and proper clause, attempts to exercise a power not enumerated, it would be, quote, an absolute usurpation, close quote.
On the sweeping clause, this dreaded clause, it declares Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. The Constitution had enumerated all the powers which the general government should have. Does this clause give any new power? I say not. Suppose it had been inserted at the end of every power, that they should have power to make laws to carry that power into execution. Would this have increased their powers? If, therefore, it could not have increased their powers, if placed at the end of each power, it cannot increase them at the end of all. This clause only enables them to carry into execution the powers given to them, but gives them no additional power.
According to George Nicholas, an advocate of ratification, the necessary and proper clause is an enabling clause that gives no additional power.
The sweeping clause, i.e. the necessary and proper clause, gives no supplementary power. It only enables them to execute the delegated powers. It is at most but explanatory. For when any power is given, its delegation necessarily involves authority to make laws to execute it.
So the father of the Constitution says that the necessary and proper clause gives no supplementary power. In effect, what he's saying is that those things that are necessary and proper for carrying into execution the foregoing powers listed above that clause in the Constitution.
Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. I understand that clause as not going a single step beyond the delegated powers. What can it act upon? Some power given by this Constitution. If they should be about to pass a law in consequence of this clause, they must pursue some of the delegated powers, but can by no means depart from them, or arrogate any new powers, for the plain language of the clause is, to give them power to pass laws in order to give effect to the delegated powers.
So according to Governor Edmund Randolph, the clause does not go a single step beyond the delegated powers.
With respect to the supposed operation of what was denominated the sweeping clause, i.e. the necessary and proper clause, the gentleman was mistaken, for it only extended to the enumerated powers. Should Congress attempt to extend it to any power not enumerated, it would not be warranted by the clause. As to the restriction in the clause under consideration, banning the transatlantic slave trade after 20 years, it was a restraint on the exercise of the power expressly delegated to Congress, namely, that of regulating commerce with foreign.
So again, the father of the Constitution says that if Congress passed a law not under the enumerated powers and merely said, quote, this law is necessary and proper, close quote, Madison said that such a construction would not be warranted.
With respect to the power to provide for the general welfare, the meaning of this clause has been perverted to alarm our apprehensions. It enables Congress to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. The plain and obvious meaning of this is that no more duties, taxes, imposts, and excises shall be laid than are sufficient to pay the debts, and provide for the common defense and general welfare of the United States.
Here, Edmund Randolph, an advocate of ratification, says that the General Welfare Clause explains why taxes can be adopted by Congress. Congress cannot adopt any law it feels will, quote, provide the general welfare, close quote.
Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. The debts of the Union ought to be paid. Ought not the common defense to be provided for? Is it not necessary to provide for the general welfare? It has been fully proved that this power could not be given to another body. The amounts to be raised are confined to these purposes solely. Will oppressive burdens be warranted by this clause? They are not to raise money for any other.
So according to George Nicholas, the General Welfare Clause limits how much money can be raised. The amounts to be raised are confined to these purposes solely, he said. It does not give any additional powers beyond those already enumerated.
On the General Welfare Clause. This general welfare was united, not to the general power of legislation, but to the particular power of laying and collecting taxes, imposts, and excises, for the purpose of paying the debts and providing for the common defense, that is, that they could raise as much money as would pay the debts and provide for the common defense in consequence of this power. The clause, which was affectedly called the Sweeping Clause, contained no new grant of power.
The General Welfare Clause only tells Congress why they can raise taxes. It is not an independent, separate, substantive power in itself, according to Randolph, an advocate of ratification.
The rhetoric of the gentleman has highly colored the dangers of giving the general government an indefinite power of providing for the general welfare. I contend that no such power is given. Is this an independent, separate, substantive power to provide for the general welfare of the United States? No, sir. They can lay and collect taxes, etc. For what? To pay the debts and provide for the general welfare. Were not this the case, the following part of the clause would be absurd. It would have been treason against common language. It is a power to lay and collect taxes, etc., in order to provide for the general welfare and pay debt. I ask the gentleman here whether there be a general, indefinite power of providing for the general welfare. The power is to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare, so that they can only raise money by these means, in order to provide for the general welfare. No man who reads it can say it is general, as the honorable gentleman represents it. You must violate every rule of construction and common sense if you sever it from the power of raising money and annex it to anything else.
According to Randolph, it would violate every rule of construction and indeed common sense to attach the general welfare to any other power. It simply states why Congress can adopt taxes. Despite what your civics teacher taught you, neither the Necessary and Proper Clause nor the General Welfare Clause delegated to Congress any additional power beyond those enumerated in Article 1, Section 8. Advocates of ratification said that interpreting these clauses in this way would violate the rules of construction, or violate, indeed, common sense. No advocate said we should ratify the Constitution because the federal government will be able to adopt any law that Congress feels is necessary and proper or is in the general welfare. The only delegates who applied this construction to these clauses were opponents of ratification who were trying to get the Constitution defeated in their state convention. Not every advocate of ratification in 1787 to 1790 expressed an opinion on these clauses, but all of those who did express an opinion on these two clauses said that these two clauses delegated no power whatsoever to the federal government.